Good morning, everyone, and welcome to Part 2, Essential Contracts in a Real Estate Transaction with Fred Pfister. Also, if you are interested in commercial contracts, join Fred on September the 29th for reviewing commercial contracts. To register, go to www.nsdcar.com/webinars. Okay, now Fred.
Good morning, everyone. Welcome to this presentation. This is part 2 of Essential Contracts in Real Estate Transactions. I'm going to be your host today for this webinar. Some of you attended the first Essential Contracts in Real Estate Transactions, and we went through the contract in detail, the purchase agreement in detail. But today we're going to go through some of the disclosure documents. So let me start this off. I know some people are still joining. I see people are still coming in here. But let me tell you a little bit about myself. For those of you who don't know me, I'm a partner at White & Bright. Some of you may have known one of our founders, David Bright, who is now retired. I've been his partner for many years and doing a lot of the same work that he did. Kind of taking up the mantle for White & Bright, which is a 40-year-old firm that has historically and continues to this day represents realtors and brokers in defense of litigation and in transactional work. We're a real estate law firm at our core. We do estate planning as well and probate litigation. But at our core, we always have been and continue to this day be a real estate firm. So hopefully we'll be your go-to source when you have issues that come up in your real estate transactions. That's what we're here for. And even after the transaction, when unfortunately you might be defending claims. And that's a little bit of what we're going to talk about here today. I approach a lot of these webinars and a lot of the presentations I do half a dozen of these a year. I approach it from a perspective of avoiding litigation on your part. And what can you do during the transaction to stay out of court, to stay out of having to talk to me after the fact and trying to defend how you worked on the transaction and what the buyer or what the seller is now saying. So that's the approach we're going to take today. I have other seminars that I do on title issues. I do some on solar panels, and I'm certainly, as Shirley just mentioned, I'm doing one on commercial forms and commercial transactions coming up here later in, she has the date, but I believe it's later in September, on commercial leases and commercial transactions, which are extremely hot. Well, I should say this, residential real estate is very hot right now. It's on fire. It's an opposite fire in commercial real estate with leasing issues are just popping up all over the place, as some of you may imagine, with restaurants and other gyms, things like that have been closed down for such an extended period of time. Anything that's really in person is taking a real hit right now, and so that will be a very timely topic to talk about some of the issues that I'm seeing representing landlords or tenants in the commercial side and also in transactions. Here's a little bit, the last thing about me is I've been general counsel for this association, which is the greatest association in San Diego County. I'm not afraid to say that. I've been general counsel since 2016, and this association is wonderful. They put on these great seminars to keep you all informed. But let's move on. Let's move to what we came here to talk about today. So those of you that were at the last meeting, or part 1 of this, know that we talked about Contracts 101 and the purchase agreement, and that took over an hour. It was approximately an hour and a half, and so therefore we decided to do a second part of this, just because that's a long time to spend on a Zoom call, and there's just so much to talk about. I mean, when you say essential contracts or essential forms in a real estate contract or in a real estate transaction, there's so many forms. I mean, a CAR puts out a book like this, and every year they add to it and they modify. And so it's hard to say what are the most important forms in the contract, because there's just so many that you encounter, which of course makes it very difficult for a buyer and seller to read them all, and which is one of the reasons why you have claims all the time, is that I continuously hear that they get that I got a stack of documents and I didn't read them all, or I got them all by DocuSign and I didn't read them all. So there's some way to get around that. But to some extent, it's about owning the transaction on your side and really explaining to them the transaction so that they are fully informed. But like I said, back to the issues that were covered here today, we're going to cover today. We're going to talk about disclosure documents, which I consider after the RPA are the most important, at least on the litigation or the prevention of litigation side. I'm going to talk about common errors that I see made by agents over and over again. It doesn't end. And then I'm going to talk about some bonus open house information, a somewhat unrelated topic, but I know that it's front and center for a lot of people because they are trying to navigate the open house rules. So let's go to without further ado, let's go to the next slide here. We're talking about disclosure documents, and where does it start? It really starts with the Form AD. This is the agency disclosure form, and there's two parts to this, but here's what I want to highlight for you. And I'm not saying that you need to spend a lot of time with this form or go over it with you should be going over this with your client, but I really want you to internalize. This is something that you really should look at. Most people just toss this one away. Oh, we sign it and we move on. But I want you to, when I say internalize, I think this is an extremely important document to look at as to what your duties are as an agent or a broker in a transaction. And it starts with, it says at the top of this form, the seller's agent and with the buyer's agent. And it's essentially an identical duty to their particular client, which is a fiduciary duty of the utmost care, integrity, honesty, and loyalty in dealings with their client. And what does that really mean? What it really means is that you have to put their interests ahead of yours. And I know we all talk about, yeah, of course I do. I always do that, but mean it. And when I say mean it, I mean, be willing to lose a deal to do that. Make sure that they know in writing. And you're going to hear this throughout today until you can't hear it anymore. Put it in writing. If it's not in writing, it doesn't exist, because people will remember it differently. So when you're looking at something like this, put the interests of your client ahead of yours in writing. That if there's something out there that they need to know, memorialize it. Not only talk to them about it, but memorialize it in writing. That, hey, we talked about this, this, and this, and you decided you didn't need that. You didn't need that inspection. That's against my advice. I think that's it. The best thing to do would be to do it, but I understand you don't want to do it for financial reasons, something like that. Because here it comes down to what the duty is, and this is to the buyer and the seller. This is what you have to do. It's honest and fair dealing, and disclose all facts known to the agent materially affecting the value or desirability of the property. And I tell people that is as the most subjective statement that you can, that's out there. What is the value or desirability of the property? Well, it means different things to different people. And so it's all about knowing your particular client and knowing also what is material, because that all has to be disclosed. And what people rely upon, I hear this a lot. They'll go down, they'll keep reading, and then they'll say, oh, wait, there's this statement down here that says an agent is not obligated to reveal to either party any confidential information obtained from that other party. And then they'll stop, right? And they'll say, well, they told me this in confidence. I don't need to reveal this. They told me that they had lots of sewer problems, or that the neighbors all have water problems, and that they haven't replaced their tank. And they've told me this, and I learned about this. But it says right here, I don't need to disclose. But they don't read the second part of this, which is that does not involve the affirmative duties set forth above. So what it's saying is don't reveal confidential information except for the the duty to disclose all facts known to the agent materially affecting the value or desirability of the property. So that's extremely important. Don't read half the sentence on, oh, I don't want to disclose confidential information, because there's a truck size exception to that, which is your duty to disclose, and it's right here on the Form AD. So I would encourage you, read this document, talk to you're learning here. I mean, it's great that you're here because you're learning this. I know they sometimes this information is glossed over, so it's always a good reminder of what your duty actually is. And I always encourage agents to talk to their broker about that, or the trainer at their brokerage, depending on the size of their brokerage. They may have someone who's a dedicated trainer or a dedicated risk management person who can discuss these issues of what are my duties under the contract. Because here's where it all comes from. That it comes from Civil Code 2079. It's the visual inspection and the disclosure of material facts and desirability. And Civil Code 1102, this disclosure must be in good faith. What that means, again, is somewhat subjective, but having a good faith disclosure is critical. And so what we're going to talk here about in the context of these disclosure duties, we're going to talk about the transfer disclosure statement. Obviously, this is a form that is filled out by the seller themselves. We're going to talk about the seller property questionnaire, again, a seller form, and of course, the one that everyone loves, the AVID. And I'll give you an example of some disclosure recommendations to do in an AVID, because I see it as a very underutilized form. A lot of agents I see hand over the TDS, hand over the SBQ, say fill this out, and then they do their agent visual inspection in a minute and a half, and it just isn't true. So let's talk about the jury instructions here, because I'd like you to take a look at this. And I know that this is going to be somewhat repetitive, and we'll look at KC 4107. And you're thinking, well, what on earth is that? I've never heard of that. What that is the actual jury instruction. So if you are unlucky enough to get into a lawsuit and unlucky enough to go to a jury on it, the jury's going to be read some instructions and they're going to judge you upon those instructions. Did you meet the standard for disclosure, for your disclosure duty? And I'll just jump right to it, because it's kind of scary, and I want people to understand why it's scary. We'll start with the first one. You know that they have the duty to disclose to their client all material information that the broker knows or could reasonably obtain regarding the property relating to the transaction. These are in the instructions. So that goes a step further, right? That goes a step further than information that you actually know. Now they're talking about could reasonably obtain. Well, could you have obtained that information? Probably, maybe, right? The other side is always going to make the argument that you had it right at your fingertips, right? You knew where the documents were. You had them in your possession. You had an email, for instance, or you had a report and you didn't provide it. How easy was it? How easy would it have been to provide that report? Here's an example I had a couple of years ago where the agent talks to there was a subsidence issue at the property, and the agent talks to the seller, and the seller says, "Oh yeah, we got a report on that back in the day, but it's an old report." Nothing's disclosed on it. Nothing happens. And what does the buyer then find out? Oh, it's a major subsidence issue. They tear up the floor and there's a crack like this in the slab, and they come after them. And one of the things that comes up, of course, is how easy would it have been? How many steps away were you from that document when you made the decision not to disclose it? How easy would it have been to take that report and just sent it over and send it over to the buyers to make their decision of whether they wanted to do more investigation, whether they wanted to buy it anyway. Sometimes in these hot markets, they'll buy it anyway, or they'll say that's not an issue. I mean, a slab like that might be an issue, but some other issues, it really depends on the buyer. But the buyer always makes the argument they didn't have the opportunity to make that decision because they didn't get the information. And so then look at the second part of this slide, which is the facts the broker must learn and the advice and counsel require the broker. And I've highlighted this, depend on the facts of the transaction, the knowledge and experience of the client, the questions asked by the client, the nature of the property, and the terms of the sale. I mean, how subjective is that, right? That's everything. That's the whole universe of information is the facts, the knowledge and experience of the client. Beware of the client who is first-time home buyer, the questions asked by the client, beware of the client who asks no questions, the nature of the property. I mean, this is all, it all goes back to, this is incredibly subjective. And you don't want to get in a situation where you're being second guessed because you hid something or you didn't fully disclose. So let me go back to this slide that we just talked about before, because I do want to highlight this issue. Is I hear this anecdotally that agents typically believe that their fiduciary duty is to save the client's money. So their duty isn't to be honest. It isn't to, well, I shouldn't say not to be honest. They think that if they save the client money, they fulfilled their fiduciary duty, which is not true. That's wrong. The fiduciary duty is to take in their interest, and their best interest may be to disclose something that ends up costing them money. And I know that may sound crazy to people who are saying, my client just has told me they want the most money, but you also may be getting them a fraud claim, and worse, getting yourself a fraud claim. And is that worth it? You may get away with it, and the client or the seller may get away with it, but it's certainly wrong. It's certainly fraud, and you could be sued for it. And guess what? If you get convicted if you get hit for fraud, they're going to end up taking your license at the DRE. And so, for what we're talking about here, it is not, your fiduciary is not to save the client money. So I want to make that sure that that's clear to everyone, because there's a real misconception out there that's essentially how you do your job. I maximize the money because that's what the client's often telling you. I want the highest price for this property, but you can't do that in the context of lying, cheating, and stealing to get that highest price, because the seller will come to you and say, well, if we disclose this, we won't get the highest price. And so you're hit with this moral argument and really a legal argument of, do I try for the highest price and commit fraud, or do I be honest, truthful, have integrity, and still sell the property likely for a very high price? And I always hear, well, the client will fire me then. And I say, good. That's not the client you want. If I have a client who comes to me and says, to my law practice, and says, we're gonna cheat on this, we're gonna lie, cheat, and steal on this, I say it's not worth it. That's not the way we conduct business here. And so I want that to be very clear in these disclosure documents, that it's not just about saving the client money, because that's the wrong thing to do on these. So let me go to another slide here where this is the common disclosure issue that we always get. And this is the source of information. So oftentimes in a transaction, you're going to get information, or you're going to either ask for information. I'm talking on the buyer side, right? So on the buyer side, you're going to ask for information, or information is going to be provided to you by the seller or some other third party. And it may be somewhat informal, right? It may be an email. It may be an oral conversation. It may be a document you've received. Or just information that you've heard about, and really what happens in these cases. There's a couple of cases that And the Salahutin case is really the seminal case on this. This is from 1994. And what that case stands for is that a real estate broker, and that also applies to an agent, cannot accept information from another person. And this includes a seller, and includes third parties, as being true and transmit it to the client without doing one of two things: verifying the information or disclosing to the client that the information has not been verified. Okay, they have to do one of the two things. I often tell people, don't verify the information. I know your client often wants you to, but you may not have the expertise. If the seller is saying the roof is the roof is great. We just had it done. We just had it done a couple of years ago. No problems at all. And if and then you transmit that as true, saying, oh, there's no problems with the roof, you better either verify that information and get some, have some expertise to go up there and get a report perhaps, or you have to disclose that the information's not been verified. And how would you do that, right? How would you do this? You essentially say, I'm not going to be, the seller said that the roof is new and has no problems. I don't know that to be true, and I'm not going to be verifying that. That information has not been verified. And so oftentimes this is what we're seeing all the time, is that in order, especially with like text messages and the quickness of communication that we have in some of these transactions, because let's be honest, some of these transactions go really, really quick, that people, they just pass along this information and they don't say that it's been verified, or they don't say that they're verifying it, and they don't say that they don't disclose to the client that the information has not been verified. So the buyer thinks it's been verified. A classic example is saying it's permitted. The seller will say, "Oh yeah, that patio is permitted," or that that outbuilding is permitted, and they don't provide any documentation on it. There's no information really on it except for their word or an email from the seller. And what does the buyer's broker or buyer's agent do? They just say, "Oh yeah, it's permitted. Oh yeah, you can split that lot. Oh yeah, you can build on this." And they don't attribute it. What you want to do is you want to attribute it to the seller and say, information came from the seller. I haven't verified whether this is accurate. I suggest you investigate this for yourself if this is important to you, because it may not be. I mean, the fact that the lot can be split, the desire may be to have a hobby farm there, and they never wanted to split that property. But that's an information that they should make the decision on, meaning the buyer should make the decision on. And so when you're making these types of disclosures, when you're getting this information from the seller or from a third party, again, that you focus on the source of the information and whether it's been verified or not. And you'll see there on this slide also, I've highlighted something from the Field versus Century 21 case, a case that a lot of you are familiar with it, that again, the same issue of advising the client that they're merely passing on information. You must provide that information. And again, how do you do this? How does an agent do this? Well, I say it's attribute, disclose, and disclaim responsibility in that order. So here's an example with oral information. I was advised about X. I was advised X about Y. For instance, I was advised the roof has no problems at all and is in perfect condition. Neither I nor my broker has investigated or verified any of this information. Buyer should investigate. I mean, you could elaborate certainly on this a little bit, but that's the basic information. You've attributed it, that you were advised about it, that you've disclosed that you haven't verified information, and you've disclaimed responsibility that the buyer should investigate if this is important to them. So you've essentially satisfied your duty doing that. Written information. This is very, very similar. Only in this, you'll likely have a physical document, which is even better than oral information, I believe. So here's an example. I received X about Y from Z, which I provided to you already, or which is attached to this email. Neither I nor my broker has investigated or verified this information. Buyer should investigate. For instance, I received an email from the seller, forwarded on by their agent, saying that the property was permitted, but they lost the permits and that the city doesn't have them anymore. You heard that before, right? Neither I nor my broker has investigated or verified this information. Buyers should investigate if this is important to them. So that's the type of disclosure that, attribute, disclose, disclaim responsibility. You may not necessarily like it because, you might say, well, my client wants me to verify this information. Well, you're walking on a plank by doing that. If you have the expertise to do something like that and to verify that's all true, and you pull up the permit, or you get some information that it actually was permitted, by all means you can verify. But I'm strongly suggesting to you that that's in most circumstances is a bad idea to do, because what if you're wrong? Is that your expertise? Are you being hired to verify permits? Are you being hired to verify that the roof has the roof doesn't have any problems with it? How about the slope next to the property? Are you the engineer who's going to determine whether this is going to fall or not and when it's going to fall? No, most of the time, I'd say 99.9% of the time, you should not be doing that unless you're a geological engineer and you're doing the reports, which I don't see people doing, right? I got this information. I suggest I recommend you get a geotech report, and you make it the buyer's decision. Make the buyer make the decision that they want to get that report. They want to pay for it because it's expensive. They want to get that report, or they want to take the risk that it's not a problem because the seller has said, oh, it's not a problem. So again, attribute, disclose, disclaim responsibility. So we're going to move now to the common errors that by agents with disclosure documents, and this is certainly with the AVID, but it's also with the SBQ and the TDS, and I'll talk about those in a second. But first I want to focus on these common errors. Obviously, the first one is verifying information they receive from a third party. That's the slide we just talked about. And it's verifying information that they receive and this isn't the attribute, disclose, and disclaim responsibility. This is actually verifying the information. So they verify it from a third party without actually doing it or doing a shoddy job. Their verification is to ask somebody else that they know who may live on that street, or some other agent in their office. Oh, is this a problem? Oh, no, that's not a problem. That's not really verifying the information. That is just getting essentially a layman's opinion sometimes. And so I see people verifying information without actually doing it is what I would really call this. And why are they doing it? They're trying to make the client happy, right? The client is on the fence whether they should release contingencies, and they want to have that client release contingencies, right? They want to make that commission. I completely understand this is an incredibly competitive business. You're in one of probably the most competitive business in terms of everyone's great at marketing. There's a lot of people who are great at this job, and it's so competitive that I see people cutting corners when it goes to, they try to verify the information. So I'm recommending to you that you don't do that. Because it's a common error that we see is verifying information that they receive from a third party without really doing it, as we talked about in the last slide. Another common error is not identifying red flags to a buyer. This is, of course, the material facts. And I see some people on the buy side, when they're looking at these disclosure forms, and on the buy side, they get these disclosure forms and there's glaring red flags. And they're just not discussing it with the buyer. They're not highlighting it to the buyer. They're essentially just moving on. And sometimes that's because the TC is running the deal at that point. Sometimes it's, I hate to say it's just they're too busy. But the claims I see against buyer's agents a lot is on the buy side, they're saying, you know, they didn't tell me what I should have been concerned about. A lot of times it comes from, you know, buyers who English isn't their first language. It comes from first-time home buyers, but it can even come from the experienced buyers. I mean, remember that we were looking at those jury instructions. It's the knowledge and experience of your client. So, you know, beware of that first-time home buyer who, with English not their first language, buying a house with all sorts of flaws, and you not sitting them down and talking to them about, well, you know, they said that there's, you know, subsidence issues. Maybe we should look into those reports again. What I'm seeing in the transactions that end up on my desk is that they're not having that conversation. They're not going over those red flags. And so the buyer feels like they're left out, like no one's looking after their fiduciary duties, or no one's looking after no one's giving them their fiduciary responsibility, that they're just looking after themselves. Other issues I'm seeing is, and also identifying those red flags in writing. That's always good as well. Remember I said I'm going to hit writing all the time. It's never a bad idea to memorialize that conversation. When you sit down and explain, you know, they're saying there was a historical subsidence issue here. You know, we may want to get a geotech report, right? Well, it's always great to have that memorialized in writing. Hey, you know, it was great seeing you today, and you know, if you actually do see people in person, or it was great talking on the phone to you today, and we talked about that subsidence issue. You know, that it was identified in the TDS, and that it was my recommendation to consider a geotech report if that issue is important to you. Please let me know if you want to move forward with that. It's our recommendation. You know, something like that, where you are memorializing that oral conversation about an issue that could be a big issue. Subsidence issues are huge. Mold issue, water intrusion is huge. Those are issues that they're big claims, big dollars. And so those are issues I would not treat lightly. That's not a doorknob. That is, you know, could be $150,000 in damage from a water intrusion issue. I tell people every time it rains, I get about 10 calls from people saying, so-and-so's claiming that I didn't disclose this water issue, or we're getting a claim now because, you know, the place got flooded immediately after the close of escrow. And so those are issues that need to be discussed and memorialized. Minimizing hiding an issue. I don't want to necessarily say hiding, but minimizing. And this I see often. What I mean by multiple versions there is different versions of an AVID or different versions of a TDS. Sometimes people will fill out one, they'll then fill out a second one. Maybe they'll repair an issue, and then they'll fill out a second one where it doesn't even talk about what they just repaired, or that there wasn't an existence of an original TDS. And that's a problem because it may be a material that sounds to me like a material issue that I would want to know as a buyer. Remember putting yourself in the buyer position. If someone had a major roof issue and then they fixed the roof and create a whole new TDS where, you know, there's no roof issue on there, wouldn't you, as a buyer, wouldn't you like to know that they fixed the roof and that, you know, who the roofer was that did it? Is there a warranty involved? What, you know, let me see the documentation. That's what I mean by minimizing or having multiple versions of disclosure documents. It's something that I see as a common error, not providing that to the buyer. Another common error, not letting the seller be the gatekeeper. I talked about this a little bit before, that the seller has the information. You may be a stranger to them. You know, they may be a friend of yours. You might have never been to their house before. The seller has lived there for 15 years. They know about their house. They know that, and what I see in that case is the seller or the agent actually filling out these documents for them. And then sometimes they do it for convenience, just the seller's uncomfortable, or maybe the seller's elderly. This is my plug where I say I do an entire webinar on selling and elder transactions, specifically trying to avoid financial elder abuse, because we're seeing it more and more in transactions where, because of the transfer of wealth from the older generation, people are holding on to property longer and longer. There's certainly tax incentives to do it, estate planning incentives to do it, and so people are holding on to these properties well into their, the years when they may be going, when they may be losing capacity. And so we're seeing lots of transactions where the deadbeat son comes in and says, "Mom wants to sell her house, and don't worry about I'll sign all the documents for her. Don't worry about it. She's, you meet her, she doesn't remember where she is. Things like that. That, again, I do an entire transaction on that, I do an entire classes on that. So look for that in the future. If for anyone who's, it's really for anyone. I was going to say anyone who sells to seniors, but maybe it's hard not to buy and sell with seniors these days. Because they hold so much of the real estate in San Diego County. And that's really what I'm talking about, San Diego County. So look for that in the future, either with NSDCAR or with PSAR. I also do these for PSAR, which is, again, a wonderful organization down there in the South. The next item here is not staying in their lane with professional inspections. That sounds a little harsh, but I see over and over people opining about things that they really have no knowledge. If you ask me what's the structural integrity of my office that I'm sitting in, I would have no idea. Oh yes, the walls look great. There's no problems. I don't know that. I just have my observation. But if someone really wanted to do if someone was concerned about and they wanted to do a structural test, that's not something I'm going to opine about. So that's what I mean by staying in your lane. The professional inspections are wildly underused, and they really should be recommended more, and let your buyers say they don't want to do them. That's what I always say, is let the buyer say that it's not important to them, rather than you not recommending it, and then the buyer coming back and saying, well, why didn't you tell me I could get a roof inspection? Why didn't you tell me I could get this inspection or that inspection? Yeah, oh, it was buried in some document. I didn't read that. We did that all in 5 minutes. That's I'm not saying it's right, but that's what they'll say. And I would love to see that in your file saying, we looked at the property today. I recommended you to get the XYZ. Let me know if that's something that you want to do. Those are the claims actually I don't see, because those are the files that never get to my desk as non-disclosure case or negligence cases. Those don't get to me because that's in the file, and the jilted buyer, passes on that claim. Next one here is resolving problems before, not after the close of escrow. That's fairly obvious to a lot of people, but again, so many people want that transaction to close that they'll say, oh, we'll see what happens. And that's just a recipe for disaster, because after the transaction closes, you really can't go back and redisclose that. Disclosing something after the close of escrow is somewhat meaningless for the context of was that fraud before I purchased the property or before your client purchased the property. So look to resolve problems before, not after the close. And these last two ones are consultation. No one knows everything, right? And so I see a lot of times people, they're embarrassed to consult their broker, especially at I'd say at the larger brokerages. They don't want to stand out as the problem person, right? The person always coming saying, I don't understand this, I don't understand that. But that's what the broker's there for. And the broker's there when you encounter a disclosure issue, you encounter a problem, to guide the agent. And for those of you who are brokers, strongly encourage you to foster that culture where people can come to you when they have a problem. It's better to resolve that problem during the close of escrow than close that transaction and 2 months later get a demand letter from an attorney saying, you committed fraud on this transaction, or you committed negligence. That's much worse. And so I strongly encourage you to consult your broker when an issue, particularly an issue on these disclosure forms or even on the RPA comes up, when there's a question that you don't know, or that you want further guidance on, consult the broker. Let the broker weigh in on this. And the same thing is not recommending that they consult an attorney when a legal issue arises. I know that is, that oftentimes people say, well, I don't want to get an attorney involved in this transaction, or the seller or buyer may not have an attorney. But if you read the CAR forms, that they tell you to do that. They tell you that if I'll read from the SPQ itself here, just so you know. And this is a note to the seller, right? And this is partially down. If you do not understand how to answer a question, or what to disclose, or how to make a disclosure in response to a question, whether on this form or on a TDS, you should consult a real estate attorney in California of your choosing. And so what I see agents making the mistake of is they're interpreting, oh, this is all we need to disclose, or this is how we should disclose it, without recommending, like they do on the CAR form, to consult with their attorney. Now, the big caveat to this, I'm waving the hands here for those of you who are just looking at the screen, is they don't need to hire an attorney. They can do it themselves. I'm not suggesting every transaction you need to hire an attorney. That would be add another cost onto a lot of transaction. But what have you lost by covering yourself and recommending it? And that's what I'm suggesting here, that if they have a question on that, recommending they consult an attorney of what they need to disclose or how to disclose, as it says in the CAR form, doesn't hurt you. In fact, I think your client will appreciate it, that you're thinking out for their best interests, and that a legal issue has come up. I see it, oftentimes, our HOA, here's a couple examples. Our HOA has a pending lawsuit. Are you going to opine about that lawsuit and what that lawsuit means, and whether there might be a special assessment or some change? No, that should be out of your lane on something like this. And that's where, recommending they consult an attorney of their choosing. You can certainly say, I recommend XYZ attorney, but getting that recommendation, that if that's important to them, just determining what that lawsuit is about, you can certainly talk to the HOA attorney, but they always should have their, you should always recommend that they have their own counsel, someone looking after them, because the HOA attorney isn't necessarily looking after them, right? They're looking after the HOA, and they might not know. And so, again, recommending legal counsel when appropriate is important. Here's a couple of additional tips specifically for the TDS and SPQ. Let the seller fill it out. I know it sounds silly, but I hate to see, sometimes, often, you have things like Glide and you have these, digital forms, obviously, to fill out these documents, but I still see a lot of them done by hand. And the thing I hate to see is when I ask, who filled this out, whose handwriting is that? Oh, that's my agent. They were right there with me walking, they filled it out and I just told them what to fill it out. Don't do that. It's open to, now you've essentially, first of all, it tells you not to do that. But second of all, now that seller's going to say, well, they're the ones who checked that box. They're the ones who said I should say yes or no. And so now you've taken the decision out of their hand and put it into your hand, which you do not want to do, because they will remember that. Even if they say they walked me through it, they'll remember that conversation a lot differently than you do when there's a claim. They'll say, oh yeah, they said that's not something I need to disclose. So they checked no. Right? Where it's a much easier on my side defending you if I can say, oh yeah, the seller checked no, it wasn't my agent. The next one is not to use adjectives. The TDS is not a marketing device. If you're and the same thing with the AVID. This could equally apply to that. It's not a marketing device. You've already marketed the property. You already got a buyer. They're already on the hook. All you got to do is reel them in. And you don't need to market it again. You don't need to say that the classic one that I've always taught, and it goes back to my partner David, was claiming that when there's an odor from the egg farm next door, that it's an aroma, right? It's not an aroma. That's an odor. That's a strong odor that no one wants to live next to, right? Except for the person who wants a discount on that house. And so there's a house for everyone, and don't use adjectives because they just come back to bite you, that you're trying to mislead with a description. Also not descriptive enough. I mean, I see that a lot is, I do not like the TDS and the SPQ, because if you look at it, and I'll just hold up without a slide here, hopefully you can see that. I mean, you guys all look at this form all the time. You can see how there's, you have this, the explanation is about, it's almost less than 2 lines. And if you can get 10 words in there, great. Of course you can, there's a box to check saying see attached, but I'll tell you, I don't see people doing that. I see people trying to fit in, they'll say fill, what's on the property? Oh, there's fill. What does that mean? Where's the fill? Is it compacted? Is it uncompacted? What's in it? It's, when you use some of these very generic or very short descriptions, you end up leading into problems where they say you were not descriptive enough, and that it was a misleading disclosure. And so that doesn't mean you have to write 17 pages on what everything is in that fill, but it would be nice to describe where the fill, if you know there's fill in the property, where it is, generally, what it consists of. Is it DG? Is it concrete? Whatever it might be, having just a little bit extra information is, I think, an important, and I see it as a common error, is that there's very brief descriptions, because frankly, this form makes people think that that's all they can do. All I can do is I only have a line and a half. How do I put in, I have problems with A, B, C, and D. How do I put the explanation for A, B, C, and D in 2 sentences? Not even 2 sentences. 2 lines on a very small type piece of paper. So again, that's a common error. No items for disclosure. This is something I see actually a lot. You would think that it'd be impossible, right? How do you have any house? I mean, you can buy a brand new house and have items for disclosure, but I don't know how many times I see a 50-year-old house, a 75-year-old house, and literally they've checked every no. And I think, well, that's all false, because every house has a problem of some sort, and I really shouldn't even say problem. I should say a disclosure issue, because what might be a problem to one person, again, subjective, isn't a problem to another person. Being next to a firehouse may be a real problem for someone who has problems sleeping. For someone who goes out and is 22 years old and goes out every night and has a great time, that may not be important to them at all, that there's a firehouse next door. So it's very subjective, but that's still an issue that would need to be disclosed, right? Let me put it out there. That should be a fairly obvious issue, that if the fire station's right next to you. But let's say the firehouse is down the street, and that's so let's make it a little bit different scenario here. I'm making this up on the spot, but let's say the firehouse is a block or 2 away, but that is the path of travel, for instance, and they're blaring and they're blaring constantly in that location. That would be, something that might not be within the knowledge of within the common knowledge of someone, that is the path of travel for the fire truck. So again, don't do no items to disclose. That's just a red flag, I think, that someone didn't spend any time on it and didn't do what they were supposed to do in the transaction. Again, tell it like it is, no sugarcoating. That's similar to no adjectives, so I'll skip that one for now. So let me do this. We're now almost 50 minutes into this. We're slated to go an hour and a half, and I have two common disclosure scenarios, and then we're going to go into a couple of last slides on some tips and tricks. It's kind of a recap, and then I'll talk about the open house. So just kind of giving those of you who have now been on this for about 50 minutes what's coming up. So we're going to do two scenarios, a recap, and then we'll do the open house issues. So let me talk about these two scenarios, because these things are near and dear to my heart, and that these were discussed at CAR at the last meeting that was actually in person, which was a million years ago, literally back in January of 2020, which is the longest year ever. So these were actual issues that were discussed, because these come up, and the suggestion was that if when you go back and you advise your brokerage, and this was an attorney only meeting. When you go back and advise your brokerage, talk to them about putting best practices into place, because there's that classic standard of meeting the standard of care, right? If you fall below the standard of care, everyone has a standard of care of how they're an agent or a broker, and if you fall below it, you may win your lawsuit, but you're going to get a lot of claims. You meet the standard of care. You can win a case, but you can lose a case. And you may get a claim, you may not get a claim. But those who go above the standard of care are the people who generally never see me. They're the brokerages who I advise on certain transactions, but they're not in the litigation. They're avoiding litigation altogether, and those agents are avoiding litigation altogether. I talk to agents all the time, and I say, how many, someone's been around 20, 30 years, and I say, how many claims have you ever gotten? 0. And I say, wow, that's not what I see. So the people I see are getting claims over and over again. They're on their 4th or 5th claim, and you wonder why, right? And I'm not saying that you could go 30 years and finally get a claim. I'm not saying that you did something wrong. It's just when you go above that standard of care, you really develop that relationship, and you oftentimes avoid seeing me. So here's with that introduction, I'll talk about scenario 1, which is a flip house or a property that your firm previously listed or purchased. So this comes up a lot. The flip context is it was bought as is from somebody, and then it was repaired by the flipper and then resold 6 months, 3 months, a year, what have you. It was sold later on. Second scenario, somewhat related, is you represented, or your brokerage, I should say, represented the buyer on a house. And then they decided 2 years later to sell that house, right? So in both instances, or at least certainly in the second instance, you should have the disclosures from that first transaction. In the flip context, you may have those disclosures, but you can certainly ask for them. And the best practice here is that your brokerage, it says you brokerage, there's my spell check, but the best practice is your brokerage should have a procedure in place to determine if they had a prior listing or sale on any new listing or sale. And it's certainly easier to do with a more recent sale. But make a copy of those disclosures and provide them to the new buyer. And you're thinking, wait a second, that was from 2 years ago. Why do I have to provide those disclosures? And really why the best practice is that there might have been something disclosed 2 years ago that is still an issue, and that still needs to be disclosed. Here's if it's a new listing and the seller says, I don't want to do that. The thing that's recommended is that you send a letter to the seller about what your broker duties are, that you have about this information. This is information you have in your possession, your brokerage has in your possession, and it's material, right? It was on the previous disclosure, right? How is that not material to the new transaction, right? And so a letter, what we're suggesting is a letter to the seller about what your brokerage must disclose and how it helps protect the seller to provide this information. And I think that's the key, to sell it to the seller to some extent. When the seller is questioning that, is say, I'm required by law to do this. Here's the law. And look at these disclosure, look at the transaction documents. And this is how it protects you, seller, by me disclosing this. It prevents you from getting a claim, from potentially getting a claim against you. And so I think that's the way you sell it. The way you disclose it is the third bullet point here, is obtain a transmittal receipt explaining that this is an old disclosure document. I'm not suggesting that this is the disclosure document, that this is a historical document. It's a document of historical nature and is not necessarily reflective of the current condition. And I would even have include standard disclosures in there regarding that. We didn't prepare this. This is, the buyer should investigate the veracity of these disclosures. But what are you doing here, right? You're providing information to the buyer to let the buyer make their own decision. And like I said, is everyone doing this? No, they're not. But are people getting claims because of this? Yes, they are. And so this is, I say this is an important consideration, especially for you brokers out there, to put this best practice into place and to teach this, that if we have a listing, because this is happening, a lot of brokerages are specific to that neighborhood, or we do all of Carlsbad, but we focus on Aviera, or we do Santaleo Hills, that's our area, or we do Escondido. And so you're doing a lot of repeat transactions on houses. And so having this information that the previous information, especially for a recent sale, is something that I'm suggesting that is the best practice to disclose this. In the context of a flip house, you didn't often represent the first when the flipper bought it. But my tip here is, if you're on the buy side of that, you're buying from the flipper, ask the flipper for the disclosures they got. If they don't provide them, oftentimes the better flippers will provide it right away. That'll be part of their disclosure. Will be giving you the disclosures they got 6 months ago when they bought the property. I like to see that. That would give me confidence as a buyer's agent that, oh, this is a stand-up flipper. It's not the flippers I've heard about who try to cheat and steal. It's one of the better flippers who's maybe flipping is disparaging, remodeling, someone who's going to remodel the house. But if I'm the seller's agent, that's one of the first things I'm asking for. Give me the disclosures you got. I know they're historical. I know you fixed all these problems, but I kind of want to know. My client might want to know, did you really fix that sewer? Because then it leads the question, if there's a sewer disclosure on the first transaction 6 months ago, and now there's no sewer disclosure, okay, it leads me to the question, what'd you do? I'd expect to see some type of document, some type of plans, some type of, maybe there's a permit, who knows what it is, but I would expect that would lead me to the next question. But if I didn't have that disclosure from that first transaction, how would I know that they were, if they didn't say anything on the second transaction, how would I know that they fixed it? Or how would I know that I should look out for that particular issue? So, and that should be a huge red flag to you, that if a flipper will not give you the original documents they had, again, red flag, that what's going on? Why, they didn't lose them, that to think that they would have lost them from 6 months ago, that just doesn't hold water. So, this is an issue that does come up, and because a lot of you, even if you're not relisting a property your brokerage originally had, a couple of years ago, a lot of you are buying houses, or you're not buying, but your clients are buying houses that were remodeled recently. Even if it was just the, someone who isn't in that business, but has done extensive remodels. That's always a tip that I talk to people about, that, okay, get the description of what they did, find out who the contractor was, what warranties, make sure those are all transferable. So that's scenario number one. Scenario number two is the nosy neighbor who comes over and says something disparaging. Now, everyone hates this, right? This happened a lot more when we actually had open houses, when they weren't what they are now. Because you often had you'd have an open house, nosy neighbor comes over and says, this house has all sorts of problems. This house, someone, there's an encroachment in my backyard and this person never took care of. You name it, the nosy neighbor will come over and say something. And the question has always been, should you disclose? And and people have gone back and forth on this, because sometimes they say, well, that person's just crazy, or that's just a made up thing, right? There's no aliens that visit at night. That's what the person's saying? Do I need to disclose that? But the courts and arbitrators are saying, yes, you do need to disclose this, because it could be a material issue. And so here's the issue, and here's the scenario. It had to do with a view obstruction, where a neighbor came over and said, by the way, we're going to start remodeling our home, next door. That's going to be in this specific area. And the person doing the open house didn't disclose that, right? They didn't disclose that because they thought, oh, that's just chatter. They didn't have any documentation on it. They didn't have any permits on it. It was just chatter that, oh, the neighbor is going to start construction. Well, what happened after the close of escrow? They started construction and they obstructed, views to the ocean. Now, there's no right to views unless there's a specific law in a jurisdiction. Del Mar has someone on it. There's a view easement, which some people get. There's no right to a view. So the buyer was out of luck, right? They're out of luck that this person was going to put up a giant wall and block their sweeping ocean views. And so, of course, what they do, they filed a lawsuit, because, of course, that neighbor said, well, I told the person about it. I told the open house that I was doing this. I'm sorry, but I told them. And they didn't tell you. Oh my gosh, you probably have a legal claim. Let me call my friend who's an attorney, and you can pursue that. Well, they did. And what was the result? That failing to tell the buyer was a breach, but also failing to tell the seller. So the seller didn't know about it. And this person came over and told it to at the open house. That agent didn't go back to their seller and say, seller, I just heard this. So the court actually found it was a breach on both sides. If you can imagine this, that not disclosing this information was, they failed both. So talk about a terrible situation. You being liable to the buyer for damages and being liable to the seller for damages. So what the courts and arbitrators are saying in these type of cases is that you do have to disclose this information. That's probably an extreme example, because a lot of times when the nosy neighbor comes over, it's a much more minor issue, I would say. But not disclosing it can leave you in a real hard spot, because you know what's going to happen after the close of escrow, right? Close of escrow, you take your check, you leave. That nosy neighbor is meeting the truck when the truck pulls up and saying, oh my gosh, I can't believe you bought, the Wilson house. None of the faucets in there work, and there's a discrepancy in the property line in the back, and you name it. They'll be meeting him in the driveway, and they'll be like, well, wait a second, I didn't know about that. Well, didn't you know I told that lovely agent who was conducting the open house all about it. She was so friendly. That's that's the way it goes, right? And then all of a sudden you're getting a nasty demand letter from an attorney saying you didn't disclose. So I'm saying avoid that. And the way you avoid that is one of the essential forms of the real estate transaction, the AVID, right? There isn't a great spot to put this in the AVID, this disclosure, but I'd suggest that you put it in the other section. I think it's on page 3, if I'm not mistaken, of the AVID. I don't have it here in front of me, but it's the other section. And what can be disclosed? How would you disclose that? You would say, during an open house, a neighbor said that they were going to be building next door. Buyer to investigate, the veracity of that or the accuracy of that information. And what it does, and obviously it could be a little bit better of a disclosure, but essentially what you're doing is you're disclosing it and giving inquiry notice so that they're not coming back to you later on and saying, I didn't know about that. Now you've done it. And because the obligation on you, as we were looking at the beginning of this discussion, is that you need to disclose what you know, including what you've been told by third parties, whether the information is delivered orally in writing. And if you're the listing agent, you got to disclose it to the seller as well. Because the seller may not know this. And I know that's a difficult conversation, but it's a conversation that you need to have because, you look at that view obstruction case, they hit them up for not disclosing to their seller because guess what happened? The seller got sued too, right? The seller got sued and the agent got sued, and the seller turned around and sued the agent. So the agent was getting it from both sides, right? They were getting it from the seller and the buyer saying you failed in your duties, and the court said yes, that's correct, you did. And my last item here is, of course, if you have a question on something like this, consult with your broker and with counsel. I mean, don't put it on yourself necessarily when, that's what your broker's there for. That's what the broker's attorney is there for, is that when you have one of these and you have a question on this, err on the side of consultation, err on the side of advice. It's always a good idea in these cases. So we're getting close to the end here. Here's some last minute items for what a buyer's agent should do when they're looking at disclosure issues. And of course, these essential forms is don't panic. No house is perfect. I think I said that before, but if you have a clean sheet of disclosures on one of these essential forms, then that's probably wrong. Rely on and defer to experts. You're not an expert in everything. In fact, you're an expert on selling homes. You're not an expert on structural engineering. You're not an expert on roofs. You're not an expert contractor. Rely on and defer to them. Let your buyer make that decision that they want to retain them. The buyer, recommend in writing that the buyer should investigate things that are important to them. There is a form that is woefully underutilized. It's I can't remember the name of it. It's the buyer. It's like the BM. Well, I can't remember exactly what the form is. It's essentially what the buyer material facts of. There's so many acronyms, but it's those of you who know, it's the buyer's form that talks about what is important to them, what's material to them. And so encourage them to use it. I mean, a lot of people don't. I rarely see it utilized, but it's a good one to use, especially for that picky buyer, that to have that in writing of what's actually important to them. Avoid guessing, theorizing, or speculating. Don't do that. Don't speculate as to what the cause of something is, or guess whether that this thing will fail or not, or theorize, well, they must have been doing this. That's always a problem. And like I said before, document the source of information, where it came from, that it's not a representation by you. You got this information from somewhere else. And that's almost always the case, by the way, when you're looking at a house, because this might be you just listed this house, right? or the buyer, I'm sorry, with the buyer's agent, you viewed this house with your own client. And so any information you're getting about this home is from a source, right? You didn't, and so document that. You didn't make this up. You got it from a source. So document that. What should a seller's agent do? A seller's agent, just like the buyer's agent, they should document the issue in writing and copy it to all parties as appropriate. Disclose. Actually disclose the information and disclose it in writing. I know it's so much easier sometimes to pick up the phone, or it's so much easier to text message. I like text messaging too, but not for disclosure issues, not in lieu of providing forms. I'll tell you how many transactions I've seen in the last 5 years, where there's a dispute over what was meant by a text conversation. Text conversations are now becoming evidence because that's the way people are disclosing things or talking about the transaction, and they're abbreviated. They no one ever puts any standard disclosure language, like I'm not going to investigate this for you. And so they're a bad device to use in lieu of, and they should never be used in lieu of disclosure forms, these essential forms in a contract. Consult your broker. Talked about that already. Log your conversations about a red flag. We talked about that already. Who, what, where, and when. Don't assume the seller has expertise. They probably don't. They might not be a structural engineer either. So don't assume that they have expertise, that when they say everything's fine, just accepting that is fine. And again, disclose the issue in writing. I can't say that one enough. So we're getting now to the end of this. That's the end of the presentation on the essential forms. Obviously there are about 150 other forms we could talk about until the end of the week. But those I see are the essential forms, the disclosure forms and the RPA. Those and so I hope you enjoyed this presentation. I do have and like the approach that we're approaching it from avoiding liability, because I see that as one of the key value adds that an attorney can provide you, is how to avoid ever talking to me about an issue that, when you've been sued. The last thing I wanted to talk about though today was and I promised to talk about the open house updates. I guess the good news and the bad news here is, the good news is that the CAR has extensive guidance on this. So I strongly encourage all of you to utilize the resources. They're on the website. I'm going to talk about a couple of items here, but they're not a substitute for checking out the CAR website. And they have a whole section on open houses and even an FAQ on it. So I encourage you all to do that. You also have likely seen that CAR is ramping up, and they have ramped up. I know there was an emergency alert out from North County or NSDCAR alerting that CAR is cracking down on open houses. I haven't seen it personally in terms of people with, one of the things that we do at my firm is we do, when people get DRE complaints, we help defend them against the DRE. And if you ever get one of those, feel free to call my office before responding to the DRE. Say that again, before responding to the DRE, please feel free to call my office or another attorney of your choice. But I haven't actually seen them any claims against any of my clients regarding open houses, but I assume they're out there because I hear it from the DRE that they're cracking down on open houses. The bad news on open houses is that the same stringent requirements that were put in place in July are still existing. And so again, people who are doing open houses, you're doing them under these strict guidelines, and here are essentially the steps. One, you have to have a prevention plan. There's actually a form for this. You've probably been inundated with CAR forms for coronavirus, but there's actually a form. It's the BPPP form, which gives you have to put a prevention plan in how you're going to prevent the virus from transmitting in the open house. So you have to essentially create a plan, but you can use this form. And so that's a really good idea to do that. Those of you who know, you have to have a digital sign-in, and you only can do open houses by appointment, with one agent and one, quote, buying party. Now, the digital sign-in process, I've seen or I've heard that people have been kind of doing that, as they're in the driveway. That doesn't seem to be within the spirit of this guidance. But again, I haven't seen anyone get rung up for that. But know that you do need to have digital sign-ins, and you do need to have specific appointments. And I think the more distance between that and the actual viewing, the better. You're also supposed to use that PEAD form, the PEAD V form, which is, I'm sure all of you who have been doing showings in the last 5 months know and love that form, and its various iterations. But please know you have to use that form. You have to have entry rules posted at the property, essentially on the front door, and you're supposed to link them to the MLS listing. Again, there's some guidance on this from CAR. CAR does a great job on this, so they can actually walk you through this. You don't have to come up with this yourself. And I suggest you don't come up with this yourself. You follow the CAR guidance on it. You're also supposed to have PPE available, like masks and hand sanitizer. So make sure you have that available, and you're supposed to clean and disinfect after each viewing. Now, this is what's really difficult is this will be my commentary on it, is they put you in essentially this position of almost like a health director on some of this, that you can clean, you can disinfect, you can put a prevention plan, but are you really in, again, this is, what's your lane, right? Is your lane to be a health director or for this, for this home and for the people who are coming, or is your job to sell the real estate? And so, that's my commentary is that you follow these plans, because that they're what's required. I don't know whether this is going to shake out into DRE complaints or litigation. Again, I haven't seen it. Hopefully, knock on wood, everyone's safe and everyone, and they're getting through this virus. But for now, these are the steps you need to take. So again, CAR's website has extensive guidance on this. Go there, and they also update it too, which is great. And hopefully they'll be updating it soon, with opening this up a little bit, so it's not as cumbersome to hold an open house as it is right now, because these are a lot of steps. It's a lot more work than you're used to in terms of an open house. But anyway, that is my presentation for today. There's my contact information. If you have any follow-up questions for me, it's often best to get a hold of me at my office here, or certainly by my email address. I love talking to agents and brokers. You're the people I represent. And I also love talking to your clients who have issues, because that's often how I'm encountering you as well, is when your agent has a question on, I got this disclosure, what does it mean? So feel free to reach out to me. I will always try to get back. If you don't hear from me in a day or two, always follow up. Because it may have just slipped by me. But again, I love representing you, and thank you all for coming today. And hope to see you on another webinar coming up. As Shirley was saying, the next webinar that we're going to be doing is on commercial real estate for those of you who are doing commercial, and that will, that includes not only leasing but transactions, and I'll even be talking about like multifamily as well as selling a commercial property. So thank you all today.
Hey, Fred.
Yes.
We
Sure.
have a few questions in the chat box. We still have a few minutes. Do you mind answering some of these?
Yes, if I can find the chat box. Let me see. Okay, here's the chat box. Sorry about that. Let's see here. The first question, when you recommend an inspection and the buyer declines, shouldn't you get that decision in writing? That is a great idea. Absolutely. I would love to see that. Short of that, if the buyer, there is a form for essentially selecting their inspections, but short of getting it in, you can't always force your client to say in writing that they're going to decline inspections. The way I would handle that is I would typically memorialize an email saying, as we discussed, I saw you, or we talked on the phone yesterday and you decided not to get an inspection. That's your choice. It's against my advice, but that's your decision. You don't have to be that harsh necessarily, but and you can wordsmith that a little bit. But essentially, memorializing and writing that they've declined it if they won't do it themselves. So yes, if you recommend an inspection, they don't get it. Love to see it in writing. If they won't do that, you do it. That's a good thing to do. The next question is, please address duty to disclose regarding vacation rentals and sober living homes. Now, let me kind of take them in stride here. I'll talk about the sober living homes first. Is that a duty to disclose? I would think it is. And if one's in the neighborhood. Now, as many of you know, they can't, if they have under a certain number of residents, and I believe it's 5, but don't quote me on that, please. I'd have to look at it again. I believe it's if they have under 5, they're allowed to be cited in residential neighborhoods, and essentially, and even an HOA can't prohibit them under certain. But there are obviously exceptions to that. But in general, they can be cited in residential neighborhoods, right? Without the ability to remove them effectively. And so in those cases, if you're buying a house next door to a sober living home, I would think absolutely that needs to be disclosed. Now, the person may never care. They may be the best sober living home that is ever, they're responsible citizens, but is it something that you might want to know if you have, if you're a buyer? Absolutely. It might be material to you. So I think that is something that should be disclosed. The same thing with vacation rentals. I know that is that's an issue that comes up a lot, and one of the issues that comes up a lot is the verification of whether you can have a vacation rental. A lot of people are selling homes or buying homes with the expectation that they can sell it as, oh, this place can be a vacation rental, or this place, it can. Is not a vacation rental. And the laws are constantly changing on that, and they're changing by jurisdiction. So what I often tell people is, don't make any representations or warranties that a property can or cannot be used as a vacation rental. That's something that they generally want to investigate, because the next day there may be a law that comes down that they can't. And so that's an issue. But also, I think the context of this question is more of, should you disclose that there are vacation rentals in the neighborhood or next door? I think yes, that's a neighborhood condition. If you read the disclosure forms, you're supposed to disclose neighborhood conditions. And is that a neighborhood condition that may adversely, that might materially affect the value or desirability of the property? You bet, right? Do you want to, you have you're a buyer and you got 2 little kids, you want to be next to the party house? Probably not. You're an older couple, wanting a neighborhood on a street. Do you want there to be 7 vacation rentals? Probably not. And and so is that information that be material to you? Yes. Now, there's a caveat to that it's, oftentimes you'll walk a neighborhood and there'll be a bunch of signs that say vacation rental. And so it's, is that fairly obvious? Yes. Maybe the disclosure in Mission Beach might be a little bit different than, Escondido, for instance, or Poway, that there's that there's an Airbnb next door. It may not be as obvious. So it does depend on the property and the location, but I would say absolutely vacation rentals are the type of thing that would be disclosed. Next question here. I found a lot of agents are lazy when completing their part of disclosures. Every property in the sun has something to disclose. Every house has easements. I agree. I think just about every house has something to disclose. I'm always shocked to see an AVID that's clean, or seller disclosures that are clean. I mean, even a brand new house might be next to power lines. It might, it might have an easement like this participant asked. So I do see that a lot, and I don't know why they spend so little time doing the AVID, because it doesn't take all that much time. But I think sometimes they don't want to disappoint this, at least on the seller side, they don't want to disappoint the seller by identifying things the seller didn't identify. And they think that they're somehow, they have that idea in their head that we talked about earlier today about how they think that their fiduciary duty is to save money, right? Save their seller money, when it's not. Their duty is to disclose. And so what they think is that if they put something in the AVID, this is what I'm theorizing, is that they put something in the AVID, that it will cause the property not to be sold, or to be sold for a lesser amount, and therefore they've done something wrong, when I think the truth is that they've fulfilled their duty. So the next question was, how far back do you need to go for these disclosures? Now, I think what you're referring to is when I was talking about that, going back and properties that you have that where your brokerage bought or sold down the line. I would say if you as a yardstick is, if you have it, disclose it. Most brokerages are keeping their records, especially now they're keeping them for 7 years, sometimes less, but they're keeping these records. And if you have it, disclose it. And so and obviously the older it is, the less important it really is. A disclosure from 5 years ago isn't nearly as important as a disclosure from 6 months ago. But, the question's always going to come up. You had this in your records. You had this digitally, because most people are keeping their records digitally now, at least on the newer transactions. You had it. How hard would it have been to just provide that and put a standard waiver disclosure saying that this is historical in nature, not necessarily what the property is like today, but it's being provided to give you more information about the property. We're not verifying the accuracy or truthfulness of these representations. I mean, how hard would that have been to do? And especially if you put a practice in place in your brokerage and have a standard statement, it's a really good practice that your firm would have. And something that can be implemented without a lot of work, as long as it kind of comes top down, is what I'm suggesting. Is it's really a top down policy and procedure for your firm to have. There's another question here. Isn't the AVID distributed to the seller, so that would be constructive notice of the disclosure? Yes, it is. But it depends on the timing of when these are done. Sometimes I see the disclosures being, well, I guess the question is the context of if you put the disclosure in the AVID and it goes to the seller, then would they have constructive notice? Looking at that view issue of that house being built, I think in that context it would have. If the person had disclosed it, we wouldn't even have the claim. So it would have been noticed to the seller. It probably also is a good idea, though, as a follow-up to that, is to highlight it in an email or something like that, saying, hey, we had a here's the type of thing that you could do. We had the open house today. This is how it went. We had this many people interested. I passed out this many cards. And oh, by the way, crazy Sheila from across the street came over and said, I wouldn't say crazy, but I would say, Sheila from across the street came over and said, XYZ about the property. It's something that we, to protect you, it's something that we should disclose. I'm going to put it on my agent's visual inspection, in order to protect us from potential claims in the event that what she said was, and again, I'm doing this on the fly here, but it's something that could be told to your your client and in the context of why it protects them. I think that's really how you have to flip this script to when you're doing this. So instead of you being shy about disclosing things because you think that the seller is going to get mad at you, I think you have to flip the script on them and say, we're doing this to protect you. We'll protect you from a potential claim, because guess what? And I wouldn't say this, but guess what? You generally have insurance, right? I hope you all have E&O insurance, and you have insurance. So when you get sued, you're typically going to get some insurance defense. Guess what the seller has? Nothing. They're not going to have any insurance. So when they get sued because they didn't disclose, they're going to be out on the limb. So when you flip that script, that's one of the things you could say. You're not going to have insurance for this. You get sued, you're going to have to, you're going to be paying a very expensive attorney to defend you in a case, and let's just disclose it. We already got we already got them. They've agreed to the price. This is the time to make that disclosure. The next question is here, and I think I have time for one more question. I know there's a number on here, but I know we've just gone over. It says here, on a previous listing, the buyer canceled because buyer saw a Confederate flag in the neighbor's garage and believed the neighborhood was a white supremacist. The neighbor was a white supremacist and canceled the purchase because of this. Car Legal said it was not necessary to disclose to future buyers because it was not about the property. Was that correct advice? I don't think so. I don't want to say Car Legal was wrong on that, but and it really does depend on the context of the information here. But if there was you only disclose what you know, right? So if you don't know that the person next door was a white supremacist, or that they, I think just that. Well, I have to think about that question, because if they were just a white supremacist and they didn't have things like gatherings, or they're not doing things that are overt, I guess putting a flag up may be overt, but just the context that the person down the street is a white supremacist may not be a disclosure. But if they were doing things like holding meetings in their house, or a bunch of people would come up every day and they'd have a protest in front of their house about being white supremacists, I'd say absolutely that has to be disclosed. So it really would depend on the facts of that situation. I don't know in this context whether just the flag. I'd really want to think about that a little bit more. But that's the type of thing that that's exactly the type of nuanced issue that you could talk to. You again, call Car Legal, call your attorney, call your broker, and get their advice and document that you what's going on, because for all you know, that they may not be a white supremacist. They could have been, a historical reenactor. I mean, people do that. They historically reenact the Civil War. They could have been that. They could have nothing. It could have nothing to do with white supremacy. So, that's a nuanced issue that you were right to reach out to someone. But that's a good example of the type of issue that don't take that on yourself necessarily. Get advice from your broker, get advice from your counsel. And here's another thing. When you talk to the seller, if you're on the sales side, tell the seller, if you have questions about how to disclose something, you can call your attorney and advise that, because that's what the documents say. The documents say that when you're talking about how to disclose, to advise them to talk to their attorney. So with that, I know we're over time. I know there's more questions. Please feel free to follow up with me if you have additional questions. Like I said, I love taking your calls, and we'll follow up in writing. So please reach out at your convenience. Like I said, I will always try to get back to you and follow up with me if necessary. But thank you all for being here today. Shirley, I don't know if I assume you're still on there, but I know we're over time, so I was going to sign off here. Again, thank you. White and Bright's my firm. There's my contact information. It's a pleasure talking to you today.